Excuse me. Call 126-012 in Ray Mark A. Roy and ask council to please come forward.
Madam Chief Justice, may it please the court. Alice Walker, on behalf of the Office of the Disciplinary Administrator, I have requested 3 minutes for rebuttal. This is an original proceeding in attorney discipline involving the respondent, Mark Roy, who has been licensed to practice law in the state of Kansas since 1991. This disciplinary action arose out of the respondent's agreement to assist an individual with the initials FK in a step-parent adoption petition. The respondent was not familiar with that area of law, had not ever practiced in it, and had never filed a petition. However, he thought that he could get up to speed and help FK. And so he charged FK $2,000 to complete the step-parent adoptions plus a $200 filing fee. Unfortunately, the respondent did not get up to speed on the area of adoption law and did not take the necessary steps to become competent to file those petitions. He did not research relevant statutes regarding how to file petitions or provide proper service. He also did not research relevant local district court rules on how to set a matter for hearing. And so what resulted is in that on January 24th of 2017, he filed one petition listing all 3 stepchildren, and that was rejected by the court. That same day, he then filed 3 separate petitions for each stepchild and indicated to his client, I assume the court is going to set this for hearing. That assumption was wrong because the local district court required him to contact the court to get a hearing date. The respondent did not do that, and the next communication happened in February of 2017, where he told his client, the matter is still not set for hearing. I'll call the court and find out what's going on. Unfortunately, the respondent did not do that, and the last documented act or communication we have was in March of 2017, where he again emailed his client and said, the matters still are not set for hearing. I'll let you know when I hear from the court. The respondent heard from the court in March of 2018. The petitions were dismissed at that time for his failure to set them for hearing. And during the formal hearing, he testified that those petitions went to the email address that he utilized for e-filing, but he didn't recall getting them, and he never notified his client of the dismissals. We're going to fast forward to March of 2021, and that's the next time that the record shows that the two had communication. FK reached back out to the respondent and asked for at least a partial refund of that initial fee. The respondent indicated that he needed to check his file and he'd get back with FK, but he did not do so. FK then hired another attorney around that same time who was able to complete those adoptions. And I believe it was June of 2021, and then filed a complaint with the disciplinary administrator's office based on the information she knew about the respondent's representation.
Just one point of clarification. Initially, there were 3 stepchildren, but ultimately, because of the time and maybe change of circumstance, it resulted in only 2 stepchildren adoptions.
That's correct. And I'd have to look back at the transcript. I think that was clarified with the hearing panel that was the request of FK at the time that he hired new counsel, was only to go forward on those 2 stepchildren. The respondent did submit an answer to that initial complaint in which he acknowledged he should have found different counsel or sent FK to different counsel to handle these adoptions. He indicated he had done work for FK and on the cases, but would refund the full amount as a showing of good faith. Unfortunately, he did not do so at that time. Our office filed a formal complaint in August of 2022, and the respondent answered that complaint on September 19th of 2022. On that same date, he sent a letter with a cashier's check to FK with the full amount of that refund. Parties then entered into stipulations of facts as well as rule violations prior to the formal hearing, and the respondent stipulated that his representation of FK violated KRPC 1.1 competence, 1.3 diligence, 1.5 fees, 1.15 safekeeping property, and 8.4G misconduct. 14 days prior to the formal hearing, the respondent submitted a proposed probation plan. The formal hearing was held on November 29th, 2022, and at the conclusion of that, Our office recommended the respondent be suspended from the practice of law for a period of 12 months with a reinstatement hearing, as we did not believe that the evidence supported that the respondent complied with Rule 227 to be able to be recommended for probation at that time. The respondent asked for a public, I think he meant published censure, or on the alternative probation. The final hearing report was issued in January of 2023, in which the hearing panel concluded the respondent did violate 1.1, 1.3, 1.5, 1.15, and 8.4, and concluded that although probation would be in the best interest of the respondent, the public, and the legal profession, it could not recommend it because the respondent failed to comply with 227 based on implementation and substance. Now, we did brief these issues, and before I get into that portion, I wanted to touch on what our recommendation for discipline is here today. I did leave that open in my brief because although my recommendation at the time of the formal hearing was that 227 was not complied with, 227F gives the respondent the opportunity to continue to make that request to this court if he complies with 227 and files an affidavit of compliance at least 14 days prior to this oral argument. At this time, and I want to get into why in a minute, I am recommending that this court place the respondent on probation for a period of 12 months in compliance with that amended probation plan. My recommendation would still be a 12-month suspension stayed for that period of probation. The reason for the change in the recommendation, and with permission of counsel, I am going to talk about some of the reports that our office has received since that final hearing report came out in January. This court gets those affidavits of compliance. You received one in, I believe, May of this year when the respondent filed his amended probation plan along with his reply brief. And you got another one, I think it was August 31st of this year. And that kind of gives an overview of, hey, I'm in compliance. I'm doing what the probation plan says. What you don't get the benefit of seeing are these reports that our office gets. And the respondent starting in April has been sending detailed reports. I got one in April, June, and August. And what the respondent does is he has listed out kind of how his practice was before the probation plan, what his practice is like after implementation of the probation plan, and then any updates. So there was an update in June and an update in August. And I'll pause to say that some of the concerns that our office had, and I think were reflected by the hearing panel in that final hearing report, is that the probation plan really focused on creating this relationship with the supervising attorney, and then the supervising attorney would kind of assess the processes of the respondent's practice. And there was really no detail in that remediation portion that the respondent was going to do. But if you look at that amended probation plan, it really has, and it actually has a full section of remediation that is several pages long, where the respondent appears to have taken into account those statements of the hearing panel, looked at what misconduct was found by the hearing panel, and put in place some of those things that would address that. There were obviously concerns regarding the respondent's beekeeping and how whether he had even put that original fee in his trust account, not having those trust account records, really not having much information in his files about communication. He also testified at length about some confusion that he expressed regarding how to close down a file when a case is completed, but he's put in place measures to address that in the plan. But then our office has information and that plan is working. And we know that from these reports. Things that I want to point out, the first detailed report that I believe I received was in April of this year. And as I said, he kind of has those different sections. In his first section, he talks about his electronic client files. And before the probation plan, the respondent had 244 active and open cases in that electronic file. After that probation plan, after he took time to kind of do some case assessment, implement some better case management practices, he was able to only have 20 active case files in April. In his August report, he only has 16 active case files. And so that shows that these practices that he's put in place have really been able to clean up that case management that he has and better focus on the cases that he actually has open. Another note that I've made regarding this.
Just real quick, those are what you just talked about, cleaned up the case management, that's reflected in his reports to you. 'Cause
Yes,
I didn't see any copies of anything like that
correct. And
to
so,
corroborate that, but you were relying on your representation of what he supplied you.
correct. And that's with permission of counsel, because obviously these aren't part of the record. These are just the reports. And I mean, you can't really see this, but this is the detailed report that he submits to our office. And this is the August one, which is the third report that has given myself that information to say this probation plan that he has created, the amended one, is actually workable. And then I also have spoken with his probation supervisor, and counsel has given me permission to bring that up. That's indicated that he is in compliance, and that supervisor also submits a report to our office saying he's in compliance. The other portion that I wanted to touch on is that in June was the first time I saw an update where the respondent and his supervising attorney kind of sat down and decided that the respondent should monthly sit down and run, I think it's a case status report and a trust and count reconciliation, kind of do that at the same time on the same date, and have a good overview of how are my cases doing? How's my trust account? Is everything lined up? Is the correct money in my trust account? Are there earned fees that can be moved to another account? And he implemented that in June. How we know that he's learning from this process is that in August, his report indicated this is a good practice. I should be doing this, but I know that I need to wait for my monthly statements to be issued. So the day I thought I could do this isn't workable. I've got to do it after I get my monthly statements so that I have all the appropriate information to do these reconciliations. And so I think that information has really affected the way that my office, myself, have viewed that probation plan. We know now that this amended probation plan is workable and that it's been implemented, and it does protect the public, the legal profession, and is in the best interest of the respondent.
I want to ask one follow-up to just that litany you just gave.
Yes.
Do you think or feel that the $2,200 that was refunded was sufficient to make the victim whole in this case? And
Based on
is there anything in the probation plan that addresses that, or was it discussed?
It was not discussed, and I think based on the evidence we have available in the record, that is the monetary loss that FK had from the representation of FK. I know there's a period of time, obviously, that was lost, but there was nothing indicated that any other monetary value would be necessary from the respondent.
There's a reference in the hearing panel's report about not satisfying the CLE requirements of the probation plan. Has that all been?
The respondent, I think it's in the affidavit that he is working on that. Let me grab the most recent report. He has actually done, it appeared to me, and obviously we would know different if he was not in compliance at the end of the reporting year. He was in compliance with that and then had done additional continuing legal education. I show that the update from June to August shows an hour of pillars of professionalism, an hour of ethics consideration of generative AI, an hour of ethics and professionalism, and then 2 hours of law practice management have been done since June. So in addition to that, complying with that year-end requirement.
And clarification, you're still seeking a suspension, but suspend the suspension and 12 months of probation at the date of the opinion from when he started complying. Where do you want that?
My request would be at the date of the opinion
Okay.
to have that implemented.
Can I ask you a question that it probably is more of just a general question that transcends the particular facts of this case, particularly since we have stipulations. But when you have a situation where you've got a competence violation, or safekeeping of property, and the factual basis that supports those, then it seems then that same conduct is then supporting an 8.4 violation, fitness to practice. Whereas I think in every case where you have incompetence, you're already going to presume that reflects on fitness to practice. and then at that point, you've got multiple rule violations, and that's an aggravating circumstance. Is 8.4 really intended to cover the gaps where there's conduct that poorly reflects on the fitness to practice, but maybe doesn't directly support other rule violations?
I think there could certainly be situations where 8.4G could stand alone, where maybe there's some behavior of an attorney that doesn't quite fit in one of those rules, and it just generally has that negative impact on that lawyer's fitness to practice law. But I do also think it is written in a way that it can be encompassed with other rule violations. And there might be rule violations where there is only a 1.1, but not an 8.4. But in this case specifically, I think it's that culmination of it. It's not just the incompetence, but then the failure to act after knowing that he wasn't competent to handle these adoptions. It's the failure to communicate with that client. He testified about moving offices and not notifying his clients that he had moved offices, and really just kind of assumed that his client would find somebody else to take care of it, rather than taking those steps that as an attorney, our duty, our fitness requires us to do for our clients, despite whether they're knocking down the door to know what's going on or not. So I think it could be in both situations. And I think it's probably a case-by-case determination of, are we just double dipping, right? Are we saying you did all those things and it's this, or is it an additional level of saying it wasn't just incompetence, it wasn't just this, failure to get up to speed on the area of law, but that in addition to everything else really affects your fitness to practice law in this situation. I recognize that I am out of time. Hopefully I can still remain my rebuttal time if necessary. I will submit the remainder of my arguments on the brief, and I'll stand for any other questions if there are any. Otherwise, I thank you for your time.
Thank you, Chief Justice. Thank you, Justices. Chris McHugh for Mr. Roy. Mr. Mark Roy appears in person. Also appearing is Diane Belquist. I'm in a little bit of an awkward position here because I cannot argue for probation probably any better than my colleague just did. And I am in complete agreement with that suggestion.
Anything you're not in agreement with what she just said?
Well, I'm sure I have to be, right? I'm an attorney. I have to disagree as much as possible. But I don't think it's anything that really impacts the resolution of the case.
As I understand it, you stipulated to all the rule violations, so there's really no questions that you have. You might have questions, but you've stipulated to those. And so we're really here dealing with what we typically deal in. There's a stipulation to the rule violations, is that's the discipline.
That's correct. That's correct, Justice. I would just fear of gilding the lily. I would just emphasize that the panel spent time on this, very smart attorneys. My colleagues spent a lot of time on this, very smart attorney. I've also spent time on it, and everyone has arrived through that work at the same conclusion and same recommendation, which is probation. And I would just urge the court to accept that. I understand that there is a slight dispute maybe on the underlying suspension, how long that should be, and I would urge the court and I guess my perspective on that is there's no reason to deviate from the 90 or 180 days, depending on what side you pick on the dissenting or the majority panel opinion on that underlying piece.
Counsel, I've having seen a number of these kinds of cases where there's a fee issue. Strikes me in this case that the restitution issue wasn't really developed and at least might be insufficient if it's weighed against prior cases. Can you shed any light on that?
I don't think that I can meaningfully shed light on it. I understand the concern. And I would probably give you word for word the same response that my colleague gave, which is we did our best. And if there was any way to make up for the mistakes made here by my client, we certainly all agree they were mistakes, and and substantive ones that did hurt people financially and otherwise. If that would have been delved into more, if we should have delved into it more, then we would have immediately paid that if that could have made up for something.
It just didn't come up is kind of what I'm hearing from either side.
We were focused on other things, right or wrong. If there are any questions, I'm happy to answer. I know there was a lot of briefing on this, on underlying legal questions that probably, again, at this point, don't matter because everyone through that work has arrived to the same point. Otherwise, my client would like to speak and address the court if you please.
Counsel.
Thank you.
Honors. I want to apologize to the court today, to the bar, to the Office of Disciplinary Administrator, and to FK. The record's clear what happened. I've been transparent, cooperative, honest, remorseful. And I have implemented a probation plan that is working, has improved my life personally and professionally, made me a better lawyer. And I think, as Alice said, the people that I am helping, I can focus on helping and put my energies, there's a clarity, there's an articulation of my law practice now that I haven't had in the past. I am meeting with my supervising attorney monthly. We do reconcile my trust account. We reconcile all my open files, all my closed files. And, you know, I must say that as much as I don't want to be here today, I have learned a lot through this process. And I am very, very grateful to Alice and to my attorney, Diane. They have worked very hard. I've not always maybe been the easiest person to work with, but I do want to be a lawyer very badly. I practiced law for 33 years. And the one thing that this process has taught me is that being a lawyer is very important to me. And I would open up myself to questions to the court now. If you have any. Thank you, Your Honor.
Anything further, Mr. McHugh? No. Walker?
May it please the court, I will waive my rebuttal time unless there's any further questions from me.
I did have one question. I don't know if it's just, I'm not taking very good notes, but did you say that you're asking for 12 months of probation?
Yes.
Okay. And so, but the respondent is asking, and what did the disciplinary panel recommend?
The disciplinary panel recommended a 6-month suspension. Well, the majority
Oh.
did.
Okay.
And I
That
think
went to
that-
the suspension.
Yes.
Okay, so you're asking for a 12-month suspension stayed, and the disciplinary panel went with 90 or 180 days stayed.
Correct.
So that's the only issue that we have, regardless of how long that is, everybody agrees it should be stayed.
Yes, I think, yes, everybody, the hearing panel did not recommend probation. They recommended a suspension. They made findings and conclusions that probation would be in the best interest, but they didn't think that the respondent
Oh,
had
right, okay.
complied. So their recommendation, the majority, so 2
Okay,
panel members indicated a 6 or 180-day suspension. 1 panel member recommended 90 days.
okay,
I recommended 12 months at the hearing panel, and I'm just maintaining that recommendation today, but I think it should be stayed.
right. Okay, now I get it. Thank
And-
you.
Yes.
Was that, I like Justice Standridge, I think my notes, I don't know if I caught, was that with your recommendation with reinstatement or no reinstatement?
At the hearing panel, I recommended reinstatement. I don't believe that one would be necessary because of the probation. I think the probation addresses all of the concerns that I had wanted to see in a reinstatement hearing. Any questions or other questions? Thank you for your time.
Thank you. Thank you to both counsel and Mr. Roy for your arguments and statements. The court will take this matter under advisement.